Welcome back to the Thomas FreeMe TV and Podcast Show. This is Thomas Show. How is everybody doing? This is Thomas FreeMe bringing you another powerful conversation. This individual I met on Facebook. We had a conversation on Facebook. I definitely wanted to bring him on my show, and I did not expect the conversation to ensue as it did. Very, very powerful, impactful, educational, something that all citizens should listen to because we are talking about our constitutional rights. Mr. Downing has a writ of habeas corpus going into the Supreme Court that deals with how our constitutional rights are violated in a bogus plea deal system that is locking up 97% of our communities, breaking apart our families. So we're going to discuss how all of our rights are being violated in that process. So let's just continue being our best selves. Let's continue uniting America, we the people, coming together, making us a strong union so we can take back our country, we the people, and build what the Constitution, I believe, was intended to build, and that's equal justice for all. We're going to get into racism. Is the Constitution itself racist, or the system that is manipulating the Constitution to appear and push its agenda of racism? So we're going to get into that discussion. We're also going to speak about race on maybe some options and opinions on how we can bridge this divide between white and black and possibly span that gap that we've created, this 400-year gap. So we're going to get into that discussion as well. Again, very impactful. Please leave your comments, likes, shares. Make sure that you are subscribed if you're not. But please join the discussion. Let me know what your thoughts are, and I will definitely bring Mr. Tanawah on again and continue this discussion. So until then, please continue to be your best self. Please continue to use your highest education, your higher learning, and just understand that we're in the face of ignorance all the time. So maybe this is a moment to teach versus become emotional. So we're going to get into all of that and more here on the Thomas FreeMe TV and Podcast Show. Enjoy. Okay, so good afternoon. Good afternoon. How are you?
I'm good. How are you?
I'm blessed, man. So how do you pronounce your name?
Tanawah.
Tanawah.
Yeah. It means glorious eagle in Sioux. That's right. Yes, sir.
That's beautiful. I've never ran across that. And that's native?
Yeah, it's Sioux.
Sioux.
Part of the Oglala tribe of the Sioux Nation, yeah.
What is it that we are going to be discussing today?
Well, there's a lot to it, so I probably got to break it up into something specific, something that you would like your audience to hear about. So most everything that I'm dealing with has to do with the slavery institution, and I think that we know that from history, we know that from the 13th Amendment, we know that from the way that the system works in general. So there's a lot of history that has to go into that in order to understand the concepts. We can certainly talk about plea bargains. That's the main thing that I'm fighting. Plea bargains are not constitutional. Nowhere in the Constitution does it say that you can convict someone in any other way other than a trial by jury. And if you look at, again, the history of it, it goes back to the convict leasing days. So it was Chief Justice Waite. It was his court that specifically allowed it. And he has a long history of misreading the law, and we know that. And most of the rulings that we're dealing with are coming from that era, an era known as legal realism. And where the judges were making their own laws that were based upon their own social, political, or public policy, and they were altering the fundamentals of the United States Constitution. So the plea bargains are one of my biggest concerns, and what we're gonna get reversed. There's a lot of precedent that exists as far as case law, as well as also statutory law that says that you cannot create a rule that impairs the obligation of the contract, or a rule that takes away a constitutional obligation. So there's that. But then as far as the case is concerned, I can talk about that as well. What I did is when I first went in, I saw what was going on. I'd never been arrested in my life. This all came from a divorce that my wife wanted. When I saw what was going on, I knew it was wrong. It was contrary to all American principles. It was contrary to everything I knew. I have a degree in law, substantive law, and I knew that something had to be done. I wasn't sure exactly what was going to be done because I had to figure out what the actual root issue was. And once I figured that out, then, of course, I had some direction to go on. But in order to challenge the constitutionality of a statute, you have to be directly impacted by the statute. So I knew that I was going to have to get convicted. So we used no contact order to allow that to happen. I didn't tell my wife what was going on. I didn't tell anybody. And I just committed to doing it. So there was no contact order violation. And there were some very specific things that happened during the trial that were brought up. And through this act of, I guess, civil disobedience, I allowed myself to fall. When I got to prison, then I spent the time there petitioning other individuals, getting everybody else to get on board because I needed as big of an army as I possibly could to bring. So I filed the first writ on April 10th, 2019. And then over the course of the next 18 months that I was in prison, I stayed there all the way through my good time, right up until the day that they kicked me out, because I needed to get as many people as possible to petition with me. And I got thousands and thousands of people to do it. So, ultimately what happened here in the state of Washington was a grand jury issue that affects 9 other states. But there's a bigger issue with the grand jury as well. And so let's just break it off into 2. So first off, there's 9 states that do not do a grand jury whatsoever. They don't do it. Here in the state of Washington, Article 1626 says no grand jury shall adjourn or summon in any county. That is directly contrary to Clause 1 of Amendment 5, which says that no person.
What do you mean? What do you mean that there's no grand jury? What does that mean for listeners that don't understand?
Yeah. So obviously, the Constitution of the United States lays the fundamentals of the law, right? The procedures and processes that must be followed for adjudication of a crime, right? So when they bring you in, they got to follow the procedures and processes. Now, Clause 1 of Amendment 5 says no person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury. That's the grand jury clause. So it requires an indictment by a grand jury in order to hold someone over for a capital crime or an infamous crime. Capital crime is any crime that results in death, punishable by death. And infamous crime, according to United States statute, is any crime that has more than 1 year imprisonment in a penitentiary, right? Now, it goes on one step further and it says it's not the amount of the time that you get sentenced to, but the amount of time you can be sentenced to. So, what it boils down to is that you got to follow certain procedures. And that particular procedure says before you can arrest someone and hold them over for a trial, you must first have an indictment by a grand jury. Now, when you consider the role of the judges and what they do, so the judges are obligated to follow what's in the Constitution. They enter into an oath or an affirmation to support the Constitution of the United States and anything that's in it. So the Constitution under Article 6 says the judges in every state shall be bound thereby anything in the Constitution or laws of any state to the contrary notwithstanding. They become the ones that are obligated to ensure that everybody has the due process is followed. So they're actually the linchpin of them all. So what happens is that you have the right to due process of law because the judges in every state have the duty to ensure that those rights are provided. So when you deal with rights in particular, and this is something that most people don't understand, is where do rights come from? Well, they come from someone else's duty to act, okay? Where there is no duty, there cannot be a right. So duties or rights always derive from another's duty to act. Now, let me give you an example, okay? In the Constitution of the United States, the first portion of it, Articles 1 through Article 6, it establishes the duties, okay? Now, we go to Article 3, for instance, and it says the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. Now, is that a right or is that a duty? That's actually a duty, and is directing someone to provide a trial by jury in order to process this individual for a criminal case. So the reason why rights are inalienable is because you don't have the right until someone else has breached their duty. That's why the duty always comes before the right. So where there is no duty, there cannot be a right. And you can't have a right violated without someone else breaching a duty to act. So in the case of Article 3, like I just said, the judge has the duty to ensure that you are tried by a trial by jury. Now, if that judge were to say to me, would you like to give up your right to a trial by jury? Before I even have that right to give up, that judge has already breached his duty, which means that it's an inalienable right. You cannot give them up. They can't. So,
but you always have that offer, though.
sorry?
You always have that offer to go to trial or take a plea.
So it's not constitutional, though. It's not legal. So within the doctrine of duties and rights, the doctrine of duties and rights are very, very specific. And this is where people get it wrong. So the reason why the duty comes before the right is this. The Constitution of the United States was signed into law on September 17th, 1787, right? So that's the actual body of the Constitution, Articles 1 through Article 6. That establishes the duties and responsibilities of the government, right? So the legislative, executive, and judicial, each within each one of the articles. So that establishes the government's duties. That came first. Then the Bill of Rights was signed into law on December 15th, 1791. The rights came after the duty. That's why the duty comes before the right, because the rights were established after the duties were put into place. Therefore, the duty must come before the rights. So where there's a duty to act, they are obligated by law to do it. So if they were to say to you, you want to give up your right to do it, before you have the right to give up, they've already breached their duty to act. So they don't have the right to do it. Now, there are actual statutes that coincide with this. A good example is the rules of civil procedures.
Well, explain how that process is in everyday court today that you're saying is breaking down. So where is the constitutional error at in the plea deal process? Them offering you the plea deal is what you're saying is unconstitutional?
So there's a couple issues that are occurring. One is you have the right to be presumed innocent until proven guilty. It's a presumption of innocence. Any irrefutable presumption of guilt is unconstitutional. So if you are presumed guilty based upon the mere fact that you've been given a charge, then that is actually unconstitutional. What happens is it shifts the burden of the burden of proof from the prosecutor, the prosecution, onto the defense. And then the defense has to go out and collect evidence in order to prove his innocence, right? And so that's unconstitutional. And in fact, it's also a violation of the international human rights standards. So it's not just, American Constitution, it's international law. So you can never, ever, ever place the burden of responsibility onto the defendant to prove his innocence, or else it would be. So.
And I understand that, but in a plea process, though, it's the plea process is at the defendant's obligation. Like a plea deal is not forced on anybody.
Oh, I beg to differ. It's forced on a lot of people.
Okay.
So the thing is that when you come into and you get arrested, right? I'm going to go off the state of Washington, because the state of Washington is somewhat unique. The state of Washington doesn't have a grand jury. They use what's called information as the charging device. There's three different ways to charge someone. One is a presentment to a grand jury. The other is an indictment to the grand jury. And the third is information. Now, what happens with information is that someone calls up law enforcement and says, this person did this to me. They take that information, and that's all that's necessary in order to proceed with charges. So here in the state of Washington, there's no investigation that occurs. They don't come in and ask the individual what their side of the story. It is simply an act where they take the information, and that information is not verified or validated. There's no third party. There's no neutral, unbiased decision maker. It's validating these accusations. And what happens then is it places an inordinate amount of power onto the prosecutor to be able to pressure individuals into pleading guilty. So they can use any number of different tactics. One would be charge loading. Another would be threatening for extended periods of time. I've seen a case. I have a friend who he was actually charged with 2 counts of first-degree murder, right? And they came at him and they told him to plead out for a 4th-degree assault. 2 murder charges. He was looking at life in prison. And then when he beat that, they came and said, okay, if you'll just plead out to a 4th-degree assault, we'll let you go. I mean, that's an inordinate power. That would have never happened had there been a neutral, unbiased third party, had there been a grand jury in place that would be verifying the accusations and determining whether or not a crime has actually been committed. It would take the power out of the prosecutor's hands. That's the whole purpose of the grand jury. The grand jury.
Well, that is the purpose of the grand jury, but I don't know if even grand juries operate in that fashion, because with my case, like I went to a federal trial, and with my case, I wasn't even made aware that I was allowed the grand jury transcripts. That was like, to get your grand jury transcripts, I found out years later you're allowed, but nobody tells you this, because
Right.
it was always a question in my mind is, how was I indicted when they had no information on me at all? Zero. The only information that they got on me came from the person that ended up snitching on me, but
Right.
we were indicted on the same day. So
Right.
how did I get indicted? That does not make no sense. The only
It
thing
doesn't.
that makes sense is that they had my phone number on his tapped line, not saying anything, just my number on his tapped line. And that's where an indictment came from for conspiracy to distribute mass amounts of cocaine.
Yeah. It's not valid. So here's the problem, right? It goes even further. So these states that don't have a grand jury, that's a black and white issue, right? That is an unconstitutional act on its face, right? Meaning that the way that the law operates is not constitutional and can never be. Like here in the state of Washington, Article 1, Section 26 says no grand jury shall be drawn or summoned in any county. That particular statute is unconstitutional on its face, meaning that it will never function constitutionally because it doesn't allow for the grand jury. There are other states that say we will have a grand jury, but then it becomes a procedural issue. Now, here's the problem with the grand jury is you're not allowing the accused to be present in the court, in the grand jury. How is the accused being given the opportunity to confront the accusations? That's the whole purpose of the grand jury. Now, we can go back to a case. There's a case from 1884 called Hurtado versus California, if we want to know the exact procedures and processes of a grand jury.
You're
What
not even
Hurtado,
allowed to have your attorney present during those grand, nobody.
So,
it's just the state.
right. So what happens is that the state has taken a side. The state is taking the side of the petitioner, right? Of the accuser. And so once the state takes the side, they now have a vested interest in pursuing and winning. So now you have basically the petitioner or the accused or the accuser coming in and presenting their case to the grand jury. Now we have an equal protection issue here. And that is that if you are being treated as though you're innocent, why are you not in that grand jury? Why are you not given the opportunity to confront that accusation?
You got some good points, man. Those are points.
And more importantly, you have an unequal protection of two citizens. You have two equal citizens. One is being allowed to present his accusation, but the other one is not being allowed to confront the accusation. You have an equal protection matter. You can't,
so
you can't arbitrate.
Let me clarify what it is that you're saying for the listener that's not really grasping. So while you and I are out conducting our daily business, right? We are just going out, we're getting up, we're going day to day, we get up, we go to work, we drop our kids off to school. There is a hearing going on about us, and evidence is being presented to 12 jurors from a prosecutor.
23, sorry. 12, it's 16 to 23.
Okay. So yeah. I'm thinking trial, but
yeah.
So you have this case that's being unfolded about you without you having any knowledge of what is going on. And if you have been following the Arbery case, the Rittenhouse case, if you've been following these cases, you can see the power of the prosecutor in the courtroom. In their opening statements, they bring whatever they say, whatever it is that they want to say. They say whatever they want to say, and they know that they have the conviction of truth behind them. As far as what I mean by that is that it's the same as a law officer in court. Right. When these people speak, they speak with the court knowing that what they say is the truth. This is evidence, what they say.
Absolutely. Right.
And this hearing is going on. Go ahead.
They're also allowed to present hearsay evidence that would not be admissible during a trial. So they're able to bring in evidence that isn't even admissible for the trial in order to secure the indictment. So they can say anything they want, essentially. The prosecutor can say anything that they want, and there's no opportunity for the accused to be able to confront the accusation. Now, that's not a grand jury, right? That's the same as not having one at all, because all that is the state saying, I want this charge and I'm going to go get it. I mean, without having the accused present to be able to represent himself, to be able to confront the accusation, you have an equal protection matter. You cannot.
And where we see that in the courtroom is when when, as you say, first degree murder, a guy gets charged with first degree murder, he don't fall under the pressure of the plea, as you articulately, laid out. He don't fall under the pressure of this plea deal for the aggravated assault. He goes to trial under this first degree murder. This prosecutor lays out this elaborate fictional case and quickly finds out that they don't have the evidence to support this case. So what do? They come now to the jury instructions and lower the charges to the aggravated assault they wanted him to plea out to.
It wasn't even aggravated assault. Fourth degree assault here in the state of Washington is words. You don't even touch the individual. It's words. It is a misdemeanor, and you don't touch anyone. If you have bodily contact, it winds up being a third degree. That's how significant this was.
So they had him charged for first degree murder to get him to plea out to essentially a misdemeanor?
Yes, it was. Yes, that's exactly what it was. And so he went to trial. And during the trial, what happened was that the individual that was the witness, she lied, and she didn't know who it was. And she said, anyway, it came to be that she had no idea who she was looking at. It wasn't him. And it came to that. So then there became some libel issues that was there. But ultimately, it wasn't him that was there. And the jury recognized that immediately. And they came back with not guilty. But the prosecutor ended up coming to him and saying, hey, plead guilty to this fourth degree assault, and we'll let you go today. Right? So he's went from literally looking at life, the rest of his life in prison, to, hey, you can get out today if you'll just plead guilty.
And I speak on this all the time. This is the overzealousness of the prosecutorial, the conduct. But so let me wrap up a summation here, and then we're going to get into what it is that you're doing now that we have a general understanding of what it is that you're talking about and how our viewers can help and such. So you are saying that the unconstitutionality is in the fact of the pressure that is applied on people to plea out by the amount of allowance that prosecutors have in pressuring us into doing things that we don't want to do. So as you corrected me when I said that plea deals are obligation, you have to obligate to take a plea. You corrected me and you said, you beg to differ. And you said that it's because of the pressure that is put on that individual. When you said that, I can't argue with you. I have to say you're 100% right, because I've been under that pressure. I have guests on my show that describe this pressure. I'm getting ready to interview somebody now that is in prison for manslaughter because he was pressured to take this plea, that they were going to arrest his family, take away his children, all of these things if he didn't take this plea. And knowing that they had DNA evidence clearing him of this crime that they withheld until he took the plea.
Exactly. And so these are intentional acts of deception. This isn't about justice. This isn't about who's wrong and who's right, who's innocent and who's guilty. This is simply a matter of enslaving individuals, sending them off to state run for-profit companies so that they can generate revenue at the expense of the citizenry. That's what this whole thing is about. These states are making billions and billions of dollars every single year at the expense of citizenry. All right. They're taking advantage of a very specific demographic, and that demographic is the poor. They are creating laws that are focused on the poor in order to enslave individuals. And we know that because the 13th Amendment says so. The 13th Amendment, which was supposed to abolish slavery, says neither slavery nor involuntary servitude shall exist except as the punishment for a crime. The moment that you say accept, it means you can have slavery, but you call it justice from now on. And these states immediately recognize that. And the moment that you allow for slavery by the states, guess what? The state is now the slave owner, right? Not only are they the slave owner, but they're the ones that are bringing the charges. They're the ones that are doing the investigating. They're the ones that are doing the judging. They're the ones that are doing the supervision. They're the ones that are profiting off of it. Here in the state of Washington, Article 2, Section 29 says Congress shall provide for the working of inmates in for-profit industries for the benefit of the state. The state is making billions of dollars off of the involuntary servitude of individuals that they are picking up. They're taking
That sounds
advantage
like
of the
peonage to
court
me.
to do it. So here's what my case is really bringing up. Okay, when we talk about pressure, all right, and establishing a contract, because that's all that a plea bargain is a contract. It's a contract of guilt. Okay, now when you deal with contracts, there's basically two different opposing options. One is blackmail or extortion. The other is robbery. Okay, so let me just tell you the difference between the two. Robbery is establishing a contract by illegal means using immediate bodily harm. Immediate bodily harm. So a good example would be, I have a gun, I point the gun at you, and I say, give me your money or I will shoot you. You give me your money and establish a contract with me for that, not because you want to, but as a result of the fear or duress that I've inflicted upon you. Okay. Now, extortion, on the other hand, is the opposite. It is establishing a contract through illegal means using future bodily harm. Okay. Future bodily harm. So when you deal with extortion, goes like this. If you don't plead guilty, I will send you to prison for 20 years. Okay. What my contract or what my case is establishing is what's called the formula of intimidation. All intimidation follows this formula. Okay, it's very simple. Okay, and once you know this formula, it will make sense. It goes like this: if you don't do X, I will do to you Y, whereby X is my envisioned outcome and Y is a result my powers can cause. Okay, I have certain powers. I'm a United States citizen. I have the power to bear arms. If I go and buy a gun and I point that gun at you and I employ the formula of intimidation, it will go like this: if you don't give me your money, I will shoot you. Right? You give me your money as a result of the fear or duress that I've inflicted upon you. That's a crime called robbery. Okay. You will go to prison for that. Now, on the flip side, if I'm a prosecutor, I have certain powers as well. I have the power to send you to prison, or the power to give you charges. If I abuse my powers, it will go like this: if you don't plead guilty, my envisioned outcome, I will send you to prison for 20 years. The result my powers can cause, you make that decision and establish that contract out of fear or duress that's been inflicted upon you. Okay. Now, in contract law, a contract is illegal if the way in which the contract is formulated is illegal. Then the contract which is formed then becomes illegal. Duress is a justifiable defense for a crime, a breach of contract, or a tort. The moment that you use duress in order to formulate a contract, it makes that contract illegal and completely breachable. Okay, you cannot use fear and duress in order to formulate a contract. You can't do it. Okay, that's
well,
the
this
problem.
is why what you're saying right there is why you can't accept a plea deal or not a plea deal, but an affidavit under duress. You know, when the cops are in, right. Anytime that you can prove that you're under duress, it makes it unconstitutional, illegal to verify what it is that you're saying.
Right. And that falls under Amendment 5. So Amendment 5 is where all this comes from. Amendment 5 says no person shall be compelled to act as a witness against themselves. Okay. That's the self-incrimination clause. Now, the key word is compelled. Okay. Compelled is defined by blacks as to bring about through the use of threats or intimidation. So anytime threats or intimidation is used in order to get you to act as a witness against yourself, that means that evidence is always in forever barred from prosecution. So when you take a plea bargain, down at the bottom of that plea bargain, it says, I did certain things and you sign it, which means that you were acting as a witness against yourself. And the way that they get you to do it is through the use of threats or intimidation, which is in violation of the Fifth Amendment. You can't do that. All these plea bargains are all unconstitutional, every one of them, because the system is taking advantage of the individual. We have a 96 to 98% rate of plea bargains across the United States of America right now. That is 96 to 98% of the cases that don't even get to tell their side of the story, and that is an egregious failure of the justice system.
It don't even make sense. And how is nobody questioning this? You know what I mean?
Who has a 98% win rate?
You know, but you know what they're telling the people, though? They're telling the people is that these people are guilty. 97% of the people that we catch are guilty. So that's how efficient our policing system is. This is what they tell the people.
The problem with that argument is if you go to the criminal procedure manual right now, okay, and you were to read the preface of it, in the second or third paragraph, I don't remember which one, second or third paragraph, it will say, and this was written by a circuit court judge from the Ninth Circuit. So federal judge, Ninth Circuit, he said, most prosecutors across the United States agree that as much as 15% of the people in prison are innocent, but that is an acceptable deviance because our system isn't perfect. I'll tell you what, that number is a lot higher than 15%, but we got them to admit to that. If that's true, and that number is accurate, then there is right now today over 600,000 people that are suffering innocent because the system's too lazy to follow the rules and to do things the proper way. We don't have to prosecute or criminalize every single thing that occurs, right? I mean, if a family, a husband and wife have an issue, you don't put a criminal element between them and separate them. Why don't you send them off to family counseling? Okay.
But why is
There's
this happening? These are the questions, is why? Why are they doing this? Why is it set up in this fashion?
Money.
That's right. So when we're sitting here,
I lost you here. Can you still hear me?
I can hear you. I can't see you.
Okay.
There you go.
There you are. Okay, back.
Okay.
So the reason why they're doing it, it's real simple.
Well, we understand.
They're treating government as though it's a business, right? They tell us every day, they say, this is the criminal justice industry, okay? That's a fallacy. It's a lie. It's an illusion, right? This isn't an industry, because an industry by definition is a subsection of manufacturing. There's 3 requirements for an industry. 1 is you must have a product that you produce. 2, you must create revenue. And 3, you must pay liabilities. All 3 of which the justice system does not do. They create criminals, all right? They create slaves. These are not something that is a product that they sell, right? So this is a group of people that are taking advantage of the citizenry by telling them lies and misinformation in order to increase their revenue. This is their industry. If the Constitution of the United States got its way, guess what? They would all be out of a job, because the Constitution of the United States says that we are to be free, right? Their job is to ensure our freedom. But instead, they're taking advantage of it. So they've taken this weapon that was meant to protect the citizenry, and they've made it a weapon against the citizenry at their own hands. But let
me ask you this on that point that you just made. Let me ask you this on just a side note, real quick. Do you think that the Constitution is I want to be careful on how I ask this. Do you believe that the Constitution was written to keep Black people enslaved? Do you think that it's a racist article to begin with? We understand the element of how life was at that time. We understand the forefathers were coming over here trying to create a new America, so to say. But do you think that article, you know, the Constitution is a racist article?
So racist, no, but I'm gonna tell you why. Okay, so there's a couple of things that we need to discuss there. First off, when we started our country, we started what was called an egalitarianism form of government, which is that all men are equal. Okay, now when you create an egalitarianism government, you must have all men actually be equal. You cannot have classes of people. You can't, because if all men are equal, then there can't be classes. The moment that you establish a class within an egalitarianism type government, you've set up that government to fail. It is going to fail, because now the government has the ability to pick a side, because there's classes, right? So we had a critical failure from our forefathers. When they created this government, it was a great plan. It was a great idea, but they messed up, and they messed up bad. What they did was they refused to raise their property up to equal status. And they left a group of people at a lower status, which has caused this, not a criminal justice system, but a criminal enslavement system.
Who was that group of people?
We needed to bring everybody up to an equal status. Everybody must start in equal status with an egalitarianism type government, or you're set up to failure.
Who was the group of people that they set aside that you mentioned?
George Washington, for instance, Thomas Jefferson, both refused to give up their slaves. They kept their slaves. And yet they created a country that says that all men are created equal. That caused a class of people or a perpetual system that can discriminate. Because the moment that you've allowed for discrimination to occur within a system that is not able to have discrimination, now you have perpetual discrimination. We can never reach a level of equality unless we restart, unless we bring everybody back to an equal status and restart. In order for all men to be equal, government and laws must first treat them equal. That's the way that it has to start.
Okay. And the reason why I asked that, going back into what we were talking about, the reason why I asked that is because if people believe that the Constitution itself is a racist article, right, then everything that we're kind of speaking of is moot, because the Constitution is the root of everything. But I don't feel that it is. I feel that it is, as most of law is just vague enough to be taken advantage of
Right.
and manipulated into how it's became today with
Yeah.
all of these amendments and just
It's not the amendments. So it's deception. Okay. So first off, I have to agree with Justice John Marshall Harlan. John Marshall Harlan was the one that provided the dissent for the Plessy versus Ferguson case, which Plessy versus Ferguson allowed for racial segregation in the South. Okay. So John Marshall Harlan said, our Constitution is colorblind and neither knows nor tolerates classes among citizens. With respect to civil rights, all citizens are equal before the law. That is absolutely true. Our Constitution isn't the one that's at fault. There's other things that are at fault. Now, here's the thing, okay? Race is not the issue. We've been told that it is for hundreds of years. We've been told that race is the problem, but race actually isn't it, okay? That is a lie. It's called a diversionary tactic, and it was created by our government in order to get our attention off of them and focused on each other. Because as long as we're looking at each other as the problem and it's race-based, that pits us, the people, against each other. And then we don't realize that the real antagonist is actually the government, okay? And the reason why it is because the roots of slavery have always been primarily economic, okay? All through history, if you owed a debt to someone and you couldn't pay that debt, you could sell yourself into slavery in order to settle the debt. It was a feasible alternative for debt management, okay? That is the root of all slavery that exists, okay? So that's an economic issue. It's not a race-based issue. That's an economic issue. Now, if we look at the criminal justice system in general, right, and we look at the adjudication process, right, you're gonna get a little bit more information from that to key on. So the way it works is this, okay? If you choose to violate the law, you incur a debt to which you are charged and then called to account so you can pay the debt. These are all very simple accounting terms, right? And accounting, of course, is economics, okay? Now, the case that I'm bringing forward dealing with the grand jury is this. Now, the way that debt normally works is if I want to purchase something from a store, a bill will first be generated, which I sign and accept. Then my account is charged and I incur debt to which I then have to pay. This is a very simple method for transactions to which anyone can understand, okay? However, if the store charges a person's account without billing them first, that's called fraud. You must always bill before a charge is generated. And how this applies to these cases across the United States is that an indictment is called a bill. So absent indictment, people are being charged fraudulently because they're not being billed first. This is a very simple system. Our forefathers, they weren't elaborate men. They weren't creating these elaborate institutions or crazy systems that only men of rich or educated or noble statuses could understand. They were simply trying to create a reconciliation system that reconciled the debt that was owed to society. That's it. It's a debt-based system. But as long as we are talking about race, the people don't realize that the problem is the government, not the people. If we came together and united, we would realize that we didn't start this problem. This wasn't black versus white. This wasn't man versus woman. Those were tactics that were created by the government in order to keep us in a perpetual state of ignorance. And it's time for us to stop this ignorance.
I mean, yes, I think the agreement is that slavery itself is not racist, but America targeted slavery specifically towards black people, you know.
So I'm not going to go into the origins of the issue because I don't know. I mean, I'm not going to say I don't.
Nor do I.
I don't see how they owed a debt.
I guess what I'm trying to do is play just devil's advocate, which I'm a white person and right. Such, but I'm just trying to understand how a black individual would view what you're saying and believe what you're saying, because I'm convicted with you. I understand what you're saying, and I'm trying to get it to where our listeners that are skeptical, because that's what I want my channel to be, for the skeptics to come and say, okay, you know, this conspiracy, I want to unite America into believing what it is that you're saying. Yeah. And so a lot of that is black people, because they have been under control of the Democratic agenda for so many years. And it's how do we get them to understand that what we're saying, if I'm articulating that correctly.
The thing that I would say to that, and I run into this a lot, I've actually, and I've been getting a little bit better at it, because it's a very sensitive subject. It's a very sensitive. I understand it is. You know, a good example is I have an individual that I'm working with down in Alabama, a great guy. He's in prison. He's going to be there for a while, but I really think that he's a good guy. And that's one thing that I've come to understand is that most of these people they're not evil. We're told that they're evil. The system says that, but that's not true. I went to prison and I was innocent of whatever. And I went there and I didn't meet a single person that I didn't like. And that's a really strange thing to say, but it's true. I was not uncomfortable until I got around the guards. They were the only ones. God sent me to prison because that's where he wanted me to be. I wasn't at all in danger. And I was there for a long time. Anyway, that's digressing. But here's the thing. This is a very, very sensitive subject. And one day I had this individual from Alabama. He said to me, he was really excited about what's going on. He knew the whole story. He knew what was happening with my case. And he said that he couldn't believe what was going on. He was thanking me for it. And in my mind, it wasn't that big of a deal. I'm thinking, well, I'm just returning to what I was before. I was already free at one point. I'm going to return to be free. It wasn't a big deal. And I kind of blew it off. But later on that day, I kind of went back and I read his message again. And I realized that this is an individual who has spent his entire life living what I've only had to live for just a couple of years, his entire life. And then his parents, their entire life, and his grandparents, their entire life. I mean, this is a group of people that have historically been treated just horribly. I know only a little bit of it because I've only had to suffer just a short period of time. These are people that have been targeted by the system for decades, for centuries. And yeah, so this is a very sensitive subject. But one thing that's really important for all of us to understand is that this is our America, all right? This isn't my America. This is our America.
We the people.
And if we want to move forward with our America, we got to figure out a way to do that. And the way that we do that is that I don't know what happened in the past. I had no control over that, okay? But what I do know is that right now, today, I want to work together. I want unity. I want us all to have peace and harmony because that is going to keep people out of jail. That's going to keep people out of prison. That's going to stop having these acts of violence against each other if we can just come together in unity. But here's the problem, okay? The court does not want unity. Law enforcement does not want unity.
The government does not want unity.
Those are not something that's consistent with their business model. So the court has been putting it into place for years and years. They've been putting it, we're talking Supreme Court. The Supreme Court for years has been putting into place rulings that are intentionally undermining the union of our government and providing for states' rights, which states' rights is simply code word for segregation and discrimination. All right. The moment that you allow for the states to have their own rights and act differently however they want, then you have a absence of harmony. The whole point of the union and what we were trying to create was harmony among all 50 regional governments. So we have peace and continuity, right? But instead, from the very start, the Supreme Court of the United States put into place rulings that allowed for the individuality of each one of these states. And when you have states that are each competing for their local interests and views, then you have disharmony, okay? You don't have equal treatment among all the locations, right? If I'm here in the state of Washington and I go over to the state of Oregon, guess what? I'm treated differently than I would be otherwise. How is a United States citizen residing in Washington state being deprived of rights secured by the Constitution and enjoyed by United States citizens in the state of Oregon? That's because of this disharmony. That's because the court and the system does not want harmony. They have been undermining the union for years. They've been undermining the Constitution of the United States.
That's the pernicious decision that you're saying our forefathers put into the Constitution was the individuality of each state versus the union, and the courts are manipulating that into such as you just described.
So our system of government prior to the Constitution, prior to becoming a constitutional-based federal republic, was a confederacy. Now, a confederacy is individual sovereign states with a loose central government, right? But they maintain their sovereignty at the edge, okay? That type of a government does not have unity. It doesn't work together. Now, when we were getting ready to move into a federal republic, there were certain reasons why we needed to do this, okay? Let me give you just three of the examples. One was there was no executive officer to oversee the implementation of the federal laws at the state level. There was no president, okay? So when we moved to the constitutional-based republic, we established an executive office, okay? And that allowed for the executive officer to oversee the implementation of federal laws into the states. Is number one. Number two, there was no high court. So there's no single court that allowed for legal decisions to be to be determined and then flowed out to a national level, so that each one of the regional governments implemented the same legal precedent. Okay, so there was no Supreme Court, so we established that as well. And the third was there was no way of requiring the states to actually implement the laws that were created at the central government. So they were picking and choosing what they wanted to do or not do. So the federal government and the central government was creating laws, and then the states were saying, I don't like that. I'm not gonna do it. Right? Those were the three main issues that we were trying to resolve when we were moving from a confederacy to a constitutional-based republic. Now, with a constitutional federal republic, there's two parts to it. One is federal, and the other is republic. Now, when you deal with a federation is simply a central government that creates the laws, right? So it's a representative government that would have of a central government that would be represented by each of the individual regional governments, and they would create the laws, and then they would federate them out to the states for implementation or administration. And that's the way it's supposed to work. So the laws would be made by the central government, and they would federate them out to the regional governments for administration and application. And what that does is it creates harmony among all of the regional governments. George Washington, he said in his farewell address, he said, in contemplating the causes which may disturb our union, it occurs as a matter of serious concern for the characterizing of parties by geographical discriminations, whence designing men may endeavor to excite a belief that there's a real difference of local interests and views. George Washington's greatest concern for the stability of our nation was having these individual regional governments having their own independent views. Because what would happen there is this disharmony. We would no longer have a United States, we would have a separated states. We have 3 times been faced with the Confederacy. First, when we were moving from the Confederacy of America to the United States of America and the constitutional-based federal republic. That was the first time. And you got to look at the two political theories that were in play. James Madison was coming up with the federal republic with a strong central government, 3 branches of government, and unity among all of the regional governments. That was what James Madison was bringing forward. And then you had the Confederacy remaining as a Confederacy, but and so the states would all remain sovereign and maintain the sovereignty, but then they would have a loose association increased at the central government level. That was the 2 arguments, the 2 political theories or national theories that were being discussed at that period of time. What ended up winning was James Madison's strong central government with 3 branches of government, and not the local improved regional government. Those were the 2 theories. The regional government didn't win. And that's interesting because states don't have sovereignty. Okay. That is another issue that the court has put forward. And I would just want to put this out there because this is very, very important information for people to understand. Okay. When you talk about sovereignty derives from the belief that the king can do no wrong. Okay. The laws derive from the king, and he has the just principles and rights to be able to do that because of his kingship. Okay. So he creates the laws, right? And as a result, sovereignty derives from him. Okay. So you can't charge a king. You can't sue a king without his permission or his consent. Okay. When we, the United States citizens, when we won our independence, we each received our freedom. And as a result, we each became essentially sovereign, because as a result of winning our freedom, we then have the freedom to do whatever we want. So in order for us to be sent to prison, or in order for us to be subject to laws, we must give our consent, just like a king would have to give his consent. We give our consent because we, the people, give the government the power to govern through the consent of the governed. We are the ones that create the laws. The laws originate from us. That makes us the sovereign, and that does not allow for the government to be above us. The government is simply now the thing is, that's the central government. When you deal with the states, okay, the decision for the states to be sovereign. There was a case in 1793 called Chisholm versus Georgia. In the case Chisholm versus Georgia, this was the first time that sovereignty was actually questioned. And in that case, an individual from South Carolina was suing Georgia for whatever it was, I don't remember. Anyway, this individual was suing a separate state that he didn't live in. And ultimately, the court came out, the Supreme Court of the United States came out and said, states don't have sovereignty. Whatever sovereignty they had, they gave up to become a part of the union because they're subject to the laws of the United States of America, and therefore they cannot be independent. Okay, so that was Chisholm versus Georgia. That was right next to the signing of the Constitution by people that actually wrote the Constitution. And they said there is no sovereignty because states gave that up when they chose to become a part of the union. So what happened then was Chisholm won. He won his case, and he was able to sue and sue the state. The state didn't have sovereignty. Well, the states then threw a fit. They threw a fit, and they couldn't believe this was happening. So what they did was they went and they had the 11th Amendment enacted. Now, we did enact it, but the 11th Amendment makes no mention to an individual suing his own state. The only thing that the 11th Amendment says is that you can't sue a different state. So I can't sue the state of Oregon because I won't have standing in Oregon. That's all it says. And if you read the 11th Amendment, it says it makes no mention whatsoever to suing your own state or agents of your own state. Okay, so what happened then was 1793, they made the decision states aren't sovereign. Then 1798, I believe, you had the 11th Amendment enacted. And when it was enacted, right, it technically overruled partially this Chisholm versus Georgia case. It said that now you just can't sue a different state. So then fast forward to 1890. Okay, so from 1793 to 1890, you have Hans versus Louisiana. It was presented to the Waite Court. The Waite Court said in their ruling, they said, we don't read the 11th Amendment literally, we read it figuratively, and we believe that it says this, or we believe that it means or implies this. The United States Supreme Court has no legal authority to alter, amend, or destroy the Constitution of the United States. That is the sole duty and responsibility of the citizens of the United States. That's in accordance with Article 1. Article 1 says this Constitution says all legislative power shall be vested in a Congress of the United States consisting of a House and a Senate. So all legislative power must be done by the people. But more importantly, the Constitution of the United States specifically identifies within Article 5 the special amending procedures to change or alter the Constitution of the United States. And nowhere in it does it say that a judge or the judicial branch has any right to alter, amend, or destroy the Constitution. That Constitution is a contract. And as a contract, I'm challenging the court. Show me where within the four corners of that Constitution it says I cannot sue my state. They can't show me that. And as a result, that is a duty. It's a duty that they must follow. And no, states are not sovereign. They can't be sovereign. But there's a reason why that was put in place. So the Waite Court made the decision that they're going to be sovereign. And they made that decision for very specific reasons, and I come back on that. But they made the decision. But it's not written in the Constitution. They altered it to do it. Now, what's important and what's interesting is that in 1995, there was another question that came forward about sovereignty. It was in the Seminole Tribe of Florida versus Florida case. And what's interesting there is the court didn't decide to overrule the sovereign immunity issue, but rather Justice Souter provided the dissenting opinion. And what Justice Souter said was there appears to be two versions of the 11th Amendment that exists. One enacted by the people in 1795, the other conceived by this court almost a century later. Justice Souter said himself that the court conceived it. It's not even based on valid law. Hans is not going to be difficult to overcome. You can't, the judicial branch has no right to alter the Constitution of the United States. But more importantly, when you look at the Waite Court and the things that Waite did and his intention, Waite was an individual that actually said that the 14th Amendment may stand forever, but we intend to make it a dead letter on the books. That's what he said. He wanted to proliferate the slave industry. You can look at his rulings that he put into place. They are horrible, disgusting rulings. Every single one of them was to proliferate the slave industry. From the Cruikshank case, where you had 150 Black Americans that were gunned down by some white people, and then he refused to prosecute them, refused to allow the federal government to prosecute them because they said that the Blacks weren't entitled to. These are horrible, horrible decisions.
Well, this goes back into what we were talking about when we're talking about the unity is trying to not tell Black people what or how we want to create unity, but to understand what it's going to take for them to trust us again. And I just had this conversation with a lady last night that I'm actually co-starring in this play that I'm getting ready to get into, because the play's titled American Son, and the whole premise of it is a Black mother that's dealing with a racist cop, and the estranged husband is white. It's a biracial, so it's on Netflix. But in that, we sat up for 3 hours last night discussing race, and it's like she said, it's going to take ownership on our part to really understand what we've done to this race of people, how we've left them behind for 400 years. And how do we make that up? It's not just saying, okay, let's just forget about it and we'll go forward from here, because you still have that gap. So how do we fix that gap?
So what I'm proposing, and this isn't out there yet, but what I'm proposing is this, okay? Justice is not about vengeance, okay? You don't heal anything with vengeance. So I think that I wrote into the introduction, or the introduction to the Supreme Court, I said, vengeance solves nothing. Casting blame fails to grasp the greater message, and our mutual hope should be reconciliation, not just with each other, but with the faith in the source of our nation's foundation. We are a nation of laws, and those laws are essential to maintaining order and peace. But more importantly, we are a nation founded on faith. We must return to the faith of our design system. Now, the reason why I say that is that we have a system today that is built upon the model of vengeance. Okay, it's a punitive system. You do something, it's going to be eye for eye, tooth for tooth. You're going to pay for the things that you've done, and that returns back to a debt-based system. That's running government as though it's a business. And if you run government as though it's a business, then the decisions that you make are going to be based upon fiscal considerations instead of societal considerations. You're going to be more concerned about the money than you are the people. And that's what's happening. We have a business that's being ran, and they think that this business needs to be run in a certain way so that they can generate revenue. And they generate revenue by the more people that they put into place, right? It's not a business. We're not in the business of creating slaves. We're not in the business of imprisoning people. We're not selling stocks of prisoners up on the New York Stock Exchange. That's not what we should be doing, right? Justice is equally concerned about the accuser and the accused, because here's the problem, okay? Hurting people hurt people. When you take a hurting person and you put him into an unhappy situation and you hurt him even more, and then he gets out and you expect him to suddenly stop hurting, that's
release
insane.
him back into the community.
Take these people. Justice is about forgiveness. It's not about vengeance. When you take these people there, when you say, listen, something happened to you at some point in your life, early childhood trauma happened to you, we need to address that issue, because that's the source of all problems. We need to recognize the fact that something happened to this individual at some point in his life that changed the trajectory of his life. We need to stop looking at what they do, and we need to start looking at what's been done to them, because something has been done to these people, and then we can start resolving this issue. But when we take people, we say, you're a piece of garbage and we're going to send you off to prison and then expect you to get better, we're not getting anything better. We're getting worse and worse and worse. And so here's the thing, right? What we got to do, first off, is we have to recognize the fact that if you're a child and you grow up without your parents, without your father or your mother, they're off prison, you have more than a 70 to 80% likelihood of going to prison yourself, okay? 92% of the people that are in prison right now have got 3 or more children, okay? So if you look at just the numbers alone, one generation, and we're going to be doubling the prison population. One generation.
You said 92% of people that are in prison right now have 3 or more children.
Yeah, that was the statistics that I read. 92% of the people in prison have got 3 or more children.
That's astounding.
The number 3, we can just go off the number 3 alone, right? And that means that of the 2 million people that are sitting in prison, well, if we within the system is 10 million. If we look at just that number alone, this is an unsustainable track that we're on. We are destroying the familial unit, and we're doing it in order to generate revenue.
And isn't that how communism is established?
Absolutely. So you break up the familial unit, right? A family can live without a country, but a country cannot survive without the family. We have to have it. So these children, we're destroying them because we're taking the family away. Now, I don't want to digress too much here, but when you look at what's happening with CPS and these children that the states are taking, they're getting paid $40,000 per child that they take into the system. That's under the Social Security Act. So these states are receiving a monetary payment for every single child that they take up and take into their custody. So there's a financial incentive for them to continue to do this. Now, all through history, children have always been an economic generator. And it's no different today. There's still an economic generator because the Social Security Administration is paying $40,000 per child that they take into their custody. And that's well known. You can pull up the act itself and you can read it. It's right there. But what's happening then is, according to English common law, the father is responsible for the child and the child's health and well-being. So the education, the food, and so on. So they have primary control and custody of a child. according to English common law. So if you want to take the child, the first thing you need to do is break up the family unit and get the father away so that he's no longer in a position to do that. Then the state can come in and take over that paternal position. And now the state is responsible for educating the child, right? State can choose what they want to teach. They're responsible for feeding the child and clothing the child, and so on. And so under English common law, the woman, you either have a free woman or you have a slave woman, right? So you either have a convicted criminal woman or you have one that hasn't been convicted. If you're a free woman, you can have your child taken away for poverty. You can have them taken away for adultery. You can have, so there's certain things that they can take the child for. But as a slave, they can take the child for any reason whatsoever. And I deal with these CPS cases all day long, and they're just sickening. But so anyway, we have this breakdown of the familial unit, and we can see why it's happening. We can see the financial incentive behind it. And yet we are destroying our country in the process, because every single one of these children, look at what we're doing to them. I mean, we're taking the father away from them. If you have a child, like,
and the mother,
it breaks my heart when I think about my son. It's been 4.5 years since I've spoken to my child, because the judge during my trial, who wouldn't allow me to testify, who wouldn't allow me to present evidence, who wouldn't allow me to call witnesses on my behalf, who prevented me from being able to defend myself completely because he wanted me in prison. All right. And that's this whole digressing. But nonetheless, that same judge, 7 months later, forced my wife to file for a divorce. And when she did, he awarded her absolutely everything of a multi-million-dollar estate, and took away my parental rights of my children without even hearing, without even contacting me, without even giving me the opportunity to be able to respond to the complaint. That same judge did all that, signed it, and stole everything from me. And so it's been 4.5 years since I've spoken to anyone, to my 3 children, seen them or spoken to them. I don't know where they're at. And when you look at the child, a boy in particular, when you take away the father from that boy, he loses his sense of self. He has nothing to aspire. That his father is the one that he looks up to, that he learns how to be a man. And that's horrible. And then when you look at the daughter's first love is her father, right? Because the daughter will marry someone just like her father. So her father's there to set the example of what she should be looking for in a man. To take away that father, what does she have to
well, that's
toward?
I mean, that's common sense and that's logic. It's both parents. That's how God created it. This is why he created a man and a woman, and they create a child, and they both raise that child because they both are implementing the nature of life into this child. And when you take away one, then it's insufficient. You can't run on half an engine. There's nothing that was built to run at 100%. Is it going to run at 50% and provide the results that you expect at 100%? It's just not going to happen. And so we know this. So why is the structure not geared around making sure that the family stays together, making sure that everything that they do is to keep our family unit strong and together? Why is our government not structured in that sense? When you ask these questions, and you have to go back to what we've been discussing, is it's a business. It's an agenda. It's a business, and we're being deceived that it's not, so it can continue to go. So to wrap this up, this has been an explosive conversation. I did not expect this at all, reaching out to you, but what is it exactly that you're doing? Where can people contact you? How can they get a hold of you and participate in what it is that you're doing?
Okay. So ultimately what I'm going to do now is I have a writ, an argument, a legal argument that's ready to go to the United States Supreme Court. It's there on a jurisdictional error, which means that it is always and forever void, right? It's not the parties involved are not legally bound to it. So the jurisdictional error was created the moment that the United States District Court of Eastern Washington chose to make a decision and a ruling on a case where they lacked personal jurisdiction over the parties involved in the dispute. My case was Tanawah M. Downing versus the state of Washington. Okay. So under Article 3, Section 2, it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, which means that anytime a state chooses to become a party in a cause, exclusive personal jurisdiction has been assigned by the United States Constitution to the United States Supreme Court. So there's two instances in which the Supreme Court has original jurisdiction, and that is anytime foreign dignitary is named a party and anytime a state is named a party. Okay. So when the state is named a party, guess what? They can no longer act as the judge and make a decision in the case. And that's supported by the Federalist number 10 by James Madison and the Federalist number 78 by Alexander Hamilton. They both talk about this issue. Now, in the case of James Madison in the Federalist number 10, it was the article titled "The Union as a Safeguard Against Domestic Faction and Insurrection." And in the article, what James Madison said is, no man is allowed to be judge in his own cause because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. So states cannot be, and they were never intended to be, both judge and party at the same time because of the bias, prejudice, partiality, which would ultimately transpire as a result of it. Anytime a state becomes a party in cause, the state no longer has legal authority to act as the judge in the cause, and exclusive personal jurisdiction has been assigned by the Constitution of the United States to the United States Supreme Court. Now, what's important to note there is that that's a duty. It's a duty. So when we talk about the Supreme Court being a court of discretion, that's an act of legislation. Acts of legislation must also conform with the Constitution, or else they will be unconstitutional. Congress can't just create an act that is contrary to the Constitution and have it be legal and lawful. So the Judicial Reform Act of 1925, which gave the Supreme Court the authority to be a court of discretion, is only constitutional so far as it complies with the Constitution of the United States. And the Constitution says that there's two instances in which the Supreme Court has original jurisdiction: anytime a foreign dignitary is named party and anytime a state is named party, which means that my case can now go to the court which had original jurisdiction in the case to begin with. The moment that the United States District Court ruled on a case in which they lacked personal jurisdiction, that created a jurisdictional error, which means that this court exceeded the power authority statutory conferred upon it by the Constitution. Now, in that judgment summarily dismissing it, the district court judge even said that he lacked personal jurisdiction, or he lacked jurisdiction in the case. So the problem is why did you rule on a case in which you lack jurisdiction? Now, like I said in the beginning, I went to prison and I got thousands of people to petition with me. We filed these cases there were hundreds going in every single day or every week. And they were going to both courts, both the Eastern Washington and Western Washington. But I had everybody use the exact same two parties, right? It was their name plus the state of Washington. And that was every single case that we submitted. So what happened then was that when it went to Western Washington, the court over in Western Washington, before that court took any action whatsoever, they ordered the court to substitute the respondent from the state of Washington to the warden. Now, why did they do that? Because that court recognized the fact that they did not have jurisdiction in a case where a state was named a party. And as a result, they had to substitute it with someone else so that they could have jurisdiction, someone that they had personal jurisdiction over. So they replaced that with the warden. Now, whether I'm right or wrong is irrelevant. What happened was there was an error that was created as a result of him making a ruling on a case that he didn't have jurisdiction. But the good news is that now that case is going to the Supreme Court, because at a minimum, the Supreme Court has to deal with the jurisdictional error. Now, what happened back in Guantanamo Bay era, I think it was 2004, there was a case called Rashad versus Bush, I think, or Rashul versus Bush. And what happened was that it went to Supreme Court, and Supreme Court made a decision that it was similar. There was in fact a jurisdictional error that they identified, and they decided to not make the ruling on it because they didn't want to have to make the ruling. Instead, what they did was they reversed the judgment, sent it back to the district court for legal and constitutionally acceptable adjudication, and the district court immediately dropped the charges. I was afraid that they would do that with me. I'd get to the Supreme Court, they'd simply reverse the judgment, send it back to district court, and then they dismiss me legally, and we'd never get into the court to actually get this argument put into place. So what I did was I presented this. My civil case is Tanawah Downing versus the state of Washington. That's the criminal case, or the civil case. My criminal case is state of Washington versus Tanawah Downing. They are the exact same parties. So if they rule and decide that the first one, the civil case, is unconstitutional, then guess what? They are automatically declaring the criminal case unconstitutional because the parties are exactly the same. Simply rearranging the order of the parties does not magically change the representation of the parties. If 1 + 2 = 3 is unconstitutional, then 2 + 1 = 3 is also unconstitutional. They are both going to be. So what that does is it requires the Supreme Court to actually make a ruling on this case. That's what I want. Say that we get the rights that are contained with the Constitution of the United States. Say that we get them. That's all I want. And then we can go on about our business, but don't continue to lie to the people. So this is what I'm doing. Okay. Because the states have done what they've done, and they've proceeded illegally and unconstitutionally. At this point in time, anyone can file a writ of habeas corpus on behalf of someone else that they feel is being held in violation of their constitutional rights. My writ of habeas corpus is on behalf of every single person who is being held within a state prison system, because every single one of those cases are a state versus them. And I'm sorry, but it is what it is. I follow God. I believe in him. I know what God's attributes are. I know what God's direction is, and I believe in him. It scares me too to think some of the things that could happen. But at the end of the day, God says release the prisoners, get them out of there. And that's what I'm trying. That's what I'm going to do. So we can do this. Amen. Because my case, when you deal with a writ of habeas corpus, it's an all or nothing deal, right? So I presented this argument to the court, right? Article 3, Section 2, the state's a party, and as a result, they can no longer judge. And under Civil Rule 60B, B4, in fact, under Civil Rule 60B4, anytime a court renders a decision in a case where they lack jurisdiction, then it becomes a void judgment. And a void judgment can always and forever be vacated. It will never be valid. And as a result, I'm not arguing for anyone's innocence. I don't know if they're innocent. That's between them and God at this point in time. But what I am saying is they're not guilty, because guilt is a process, and the state did not follow that process. And as a result, you cannot violate the law in order to enforce the law. Follow our laws. They're in place for a reason. Follow them. And if you don't want to follow them, great. Then we'll just have lawlessness. But you cannot justify a criminal act in order to pursue a criminal act. You can't do it. So if anyone wants to get in touch with me, I would recommend that they start with Facebook. I've got the contact information there. But ultimately, I need people's prayers. I'm not asking for money. I'm doing this because it's the right thing to do, because I just know that if I could win my case, then the way that it works is we all win our case. And I'm only asking that they enforce the laws as written. I'm not saying change anything. I'm just saying if the laws say that something will be done in a certain way, then we must follow that way. Laws do not change arbitrarily. That's tyranny. Constitutionalism demands that the laws evolve only through suffrage. Therefore, it's up to the people to decide whether or not the Constitution applies to them, and not a judge or a state. Let the people decide if, in the opinion of the people of the United States, any of the provisions or guarantees of the United States Constitution are in any particular way wrong, then let it be corrected by an amendment in the way in which the Constitution so designates. Until, if and when that time comes, every single United States citizen is entitled to every single right secured by and enumerated in the United States Constitution. That's what I'm doing. Thank you so much.
There's some ugly, sadistic monsters on the other side of that writ that you're talking about. And I agree with you 100%, but I worry about your safety in these matters, because
I mean, it is what it is. If my safety is in danger because of, sorry, if I believe that if I were in danger, I think that the opportunity is passed. If they were going to do something, they should have done something to me while I was in prison. It could have went away. No one would have ever known. I've been told that one of the big reasons why I'm probably still alive and still doing what I'm doing is because I put everything out there. I'm blatantly honest about it, and I blast it out there. And there's more than enough information. And I'm not really doing anything wrong. I'm simply saying I love America, right? And
yeah, but you're interfering.
We need to defend America.
You're interfering with some big players.
Yeah,
that have a big agenda.
Right.
And
unfortunately, I can't change what God is asked me to do.
I mean, I'm with you, brother. Listen, I'm with you 100%. You're on my channel. And like I say, I bring some controversial things onto my channel that exposes a lot of the corruption that goes on within our court system and within our America. And I'm with you 100%. I mean, if they come and they do what they do, then that's just what it is. And I tell my subscribers, my listeners, whatever, if I disappear, you know what it is, so, but it's, I really want Americans to understand the pressure in doing what it is that you're doing, because they don't understand. Like when you file this inside a prison, what happens to you?
So I was very, very concerned about that. And before I filed, I had to take certain measures to protect myself, right? First off, I spent the first 6 months that I was there handwriting and recording the entire Black's Dictionary, the entire Criminal Procedure Manual, and the entire Civil Rules of Civil Procedure. I hand wrote every single one of them, hand copied it. I spent 6 months doing that. I had thousands of pages of that because I knew that the moment I filed, those books would disappear. And sure enough, they did. Right? I knew that. So one of the first things I did was I recorded everything I needed to be able to proceed with this. That was number one. Number two, I was concerned about the fact that this is a valid argument. And if I have a valid argument, they're not going to keep me in general population so I can spread this around. So before I filed, I already had 49 other people that were on board. They already had their paperwork filled out. So the day that I filed, they were already scheduled to file as well. By the end of that week, we had the first 49 people in, and that gave me the numbers to be able to protect myself, right? I had conversation with the warden. The warden indicated that that I can get you on inciting a riot. And I had to explain to him, sir, this isn't your fight. Don't get involved in this, because if you get involved in this, then you're going to be violating my right to peaceably assemble and petition the government for redress of grievances.
I have been charged with that inside a prison as inciting a riot for exactly what it is that you're talking about. So
right. And so I was threatened with that, but he ultimately agreed. At the end of the day, this isn't your fight, sir. Don't get involved in this, because if you do, then I'm going to be coming after you as well. And he didn't need that. I spent the whole time in prison, and you want to know, I never had my room even checked. I never got talked to. When it came time for me to leave, I think I had 9 months worth of good time. They never even asked me. They would walk by my room and say, all we need is just an address and you can get out. I don't want out. I'm here for a reason. I'm going to be here until the day you kick me out of here. I never felt in danger. Those people that were there, they knew why I was there. They called me the preacher, right? And they knew why I was there. And once I started showing them that this is what I'm doing, I had all the protection in the world. Those guys, I'm good with them, and I owe them my life because had it been anything different, it would have been a different scenario for me. But these people, they protected me. They took care of me. I had the Southsiders that told me I can go out to the yard by myself, and they'll protect me. Along with the white, everybody protected me and took care of me because I was there for a reason. And I mentioned this yesterday in a posting, but when I first got to prison, that first Sunday, there were less than 30 people who attended that prison or that service. The day I left, or the last Sunday before I left, it was standing room only, 350 people, and the line was still 200 yards out the door, or 200 feet outside the door. It stretched almost all the way to medium security side. That is what happens with hope, right? These people, if you want to change the world, if you want to do something, are you going to go to the ones that are filled with hope, that have a job and a house, a car? No, God's going to send you to the hopeless, because who better to fill with hope than the hopeless? That's where we needed to go to create this change. These people were looking for something better. They were just looking for something to believe in. Amen. And I gave them something to believe in. And once we did, everything changed. The whole morale of that facility changed. And so my point is that I've seen some amazing things. I've seen what can actually happen here. I believe personally that once I became a Christian, God sent me to prison. All right. That's where he sent me. And so, as a Christian, I'm able to feel, when I'm around people that I should be nervous about. None of these people ever made me feel nervous. Not one of them. Not one of them. And I was among some pretty supposedly bad people. They kept me in medium security the whole time. And because they just decided they wanted to. So, I was in a lockdown pod, and, but at the end of the day, these people weren't in danger. They weren't threatening to me. They became my brothers, and I love them very much. And I made the promise to them that I will not stop until I get them home. I made promises to many daughters and many wives that I won't stop. I've got 3 master's degrees. I was very, very wealthy. I don't care about that anymore. What I care about is this, because I spent the first half of my life using all my expertise and my talents to better myself, or to benefit myself. And I benefited a lot. I mean, I literally could buy anything I wanted, but with the swipe of a pen and in an instant, all of that was taken away, and I have absolutely nothing anymore. So I just figured the second half of life, I think I better use all my talents and expertise on someone else, and let's see if we can make something that's going to last. And I feel so much better about doing it this way than the other way. And, so I made the promise to more than enough kids that that we're not going to stop until we get their dads home, because
amen. I'm with you,
what's
man.
important.
Absolutely. I'm with you. I made those same promises, and this is why I'm doing what I'm doing. And one of the dudes I made a promise to 10 years ago, I just got hit on core links not too long ago. And because I'll send him notes about how my progression, and he's like, man, you kept your word, man. And that very few people do that, so people see that you and I keep our word, and we try to do what we can do, and it's appreciated. So Tanawah, thank you so much for this conversation. I do want to bring you back on again sometime and really get into the Constitution, because I'm ignorant in the Constitution, and I know 99% of other Americans are as well. And I want to really just start getting into just the Constitution, understanding what our rights are, how the Constitution was formed, all of these things. So if you don't mind, I would love to bring you back on that. And great conversation, man. Thank you so much. How can they get a hold of you?
I would go to Facebook. So just do a search for my name. There's no other Tanawah that exists. That's Tanawah. Last name is Downing, Downing. If you would connect with me through there, that'd be great.
Perfect.
Feel free to send me a message. I'll respond with contact information. The problem that I have is that I have to be a little bit concerned about where I get information and who it is, because I never know who's actually on the other end of that line. And when you look at what was going on during Plessy versus Ferguson and the Brown versus Board of Education period of time, and Dr. King, they were bringing in individuals to incite criminal statements or things along those lines. I've had people that have been brought into my Facebook site that I know shouldn't be there. I know that they were wrong. They were asking the wrong questions. So I'm a little bit leery about that. So if you'll connect with me, and if you'll just give me a moment to actually confirm who you are, then I would love to talk with you. And everything I know is free. What God gives freely to me, I give freely to everyone else. What's important here is that this knowledge goes to everyone. It's not about paying for it. It's not about hoarding it. It's about everyone sharing in this knowledge and spreading it, because the more that spreads, the quicker the Supreme Court of the United States is going to open their doors and allow me in to present this argument and get those guys home to their families. Thank you.
Amen. Amen, man. I mean, it's here again. This is Thomas FreeMe, and I'm bringing another guest on to unite America and just educate and just try to bring us together to make us, one strong, harmonious unit. And we can just put the power back into the people's hands. So Mr. Tanawah, again, thank you for coming on the show. Love to see you back again. Take care. Stay blessed. Till the next time, everybody, continue to be your best self. Stay out of your emotions. Think logically, realistically, and let's keep this thing pushing.
God bless America. Thank you so much.